participants in today's compliance conference. Allow me to adopt the protocol already established. Firstly, I'd like to express thanks to the host for allowing the FIU the opportunity to be a presenter in part one of this conference. It is indeed our pleasure. I would like to place on record that the topic today spans across all competent authorities, and therefore the information being provided in this presentation is from the perspective of the FIU only. International cooperation is indeed a weighted topic, and I believe there is need for more effective communication in order to ensure that we position Anguilla as an effective jurisdiction within the overall risk and context in the next round of mutual evaluations. As such, our objectives today are to discuss what is international cooperation, its types and its importance, the role of industry partners in international cooperation, Anguilla's efforts in relation to international cooperation, the challenges experienced by the FIU, and finally, how we can overcome those challenges. International cooperation can be defined as the interaction between two or more jurisdictions or institutions with the goal of sharing information and resources to achieve a particular goal or objective. Alexander Fleming once said, "The more complex the world becomes, the more difficult it is to complete something without the cooperation of others." This is exactly the fate that we are up against as nations. Financial crime is a global issue. No country or authority can realistically believe that an investigation into a financial crime will not or may not lead to international waters. Financial crimes most often lead to cross-border movement of funds. As such, international cooperation is pivotal in bringing actors to justice. International cooperation is therefore critical in our fight against money laundering, terrorist financing, and proliferation financing for the following reasons. It is a vital tool in combating money laundering, terrorist financing, and proliferation financing because it allows the sharing of intelligence between FIUs and law enforcement agencies. It provides a mechanism for the provisions of evidence, locating and extraditing criminals in response to mutual legal assistance requests. It allows for the identification, freeze, restraint, seizure, confiscation, and forfeiture of assets linked to criminal conduct and the sharing of such proceeds. Over time, it can make a country unattractive for criminals to operate, hold assets or property, maintain their legal proceeds, or use it as a safe haven. International cooperation can take two forms by way of legislation or through the signing of bilateral or multilateral agreements between institutions or jurisdictions. International cooperation through mutual legal assistance relates to the use of legal requests from one jurisdiction to another for the provisions of evidence, service of documents, extradition, the restraint, freezing, and confiscation of forfeiture of assets reasonably linked to criminal conduct. These legislative means provide for reciprocity. Anguilla has 4 legislative provisions to enforce mutual legal assistance for evidence. They are Mutual Legal Assistance USA Act, Mutual Legal Assistance Tax Matters Act, Criminal Justice International Cooperation Anguilla Act, SIGICA, Tax Information Exchange Acts signed between various jurisdictions, Mutual Legal Assistance USA Act and the Tax Matters Act relates to the provision of evidence between Anguilla and the United States of America. The Mutual Legal Assistance USA Act relates to the provision of evidence upon request, while the Mutual Legal Assistance Tax Matters Act provides provisions for evidence upon request relating to tax information only. Criminal Justice, the Criminal Justice International Cooperation Act pertains to mutual legal assistance from any other jurisdiction. The Tax Information Exchange Act refers to the exchange of tax information with signatory countries, each of which have their respective receiving authorities. Under SIGICA, the governor is a receiving authority for all requests. Under the MLA USA Act, the Attorney General is the receiving authority. Under the Tax Information Exchange Act, the Permanent Secretary of the Ministry of Finance has the receiving authority for all requests. Other forms of international cooperation is considered a less formal means of establishing international cooperation. It is inclusive of the establishment of bilateral and multilateral agreements or memorandum of understandings signed between jurisdictions or competent authorities to facilitate the exchange of information. The FIU currently has 12 bilateral MOUs and 1 multilateral MOU in place to facilitate reciprocal sharing of information in a timely, secure, and confidential manner. As a member of the Egmont Group, the FIU is able to utilize its secure web platform for the exchange of information between member FIUs globally upon request or spontaneously without the use of an MOU. However, some countries, though they are a part of the Egmont Group, may still enter into an MOU. The FIU also utilizes the Asset Recovery Interagency Network for the Caribbean, Carib, for the exchange of information and the requests for assistance between law enforcement agencies in asset recovery matters. An effective and efficient international cooperation regime is guided by international standards, such as FATF Recommendations, which have the key objectives to establish international standards in combating money laundering and terrorist financing, promote the development of reliable and efficient regional structures organized along the same lines, promote cooperation with relevant international organizations, and promote cooperation between competent authorities domestically or internationally. In order to promote cooperation, FATF created 5 recommendations to ensure jurisdictions have the legal framework and mechanisms in place to specifically deal with cooperation. These are recommendations 36 through 40. Recommendation 36, International Instruments, provides that jurisdictions should take steps to become party to various conventions. Recommendation 37, Mutual Legal Assistance, which indicates that jurisdictions should provide the widest range of mutual legal assistance in relation to money laundering, terrorist financing, and proliferation financing. Recommendation 38, Mutual Legal Assistance with regard to freezing and confiscations, provides that jurisdictions should have the authority to identify, freeze, seize, and confiscate property linked to financial crimes. Recommendation 39 speaks to extraditions, which provides that jurisdictions should have the legal framework that allows it to execute extradition requests in relation to money laundering and terrorist financing without undue delays. And recommendation 40, other forms of international cooperation, which provides that jurisdictions should have the authority to use the widest range of international cooperation in relation to money laundering, terrorist financing, and predicate offenses, both upon request or spontaneously. During the third round assessment in Anguilla in 2009, Anguilla was rated for its technical compliance based on FATF Recommendations 36 to 40 and Special Recommendation 5. The table displayed is a summary of the ratings with respect to the recommendations at that time. The table shows the ratings of compliant for recommendations 36, 37, 38, and 40, and a rating of lodged compliance for recommendations 39 and special recommendation 5. Since the revision of recommendations in 2012, jurisdictions will be assessed in the fourth round using the FATF recommendations, FATF 40 recommendations for technical compliance and 11 immediate outcomes to assess the jurisdiction's effectiveness in the application of the AML CFT provisions. As such, Anguilla will be required to be technically compliant with the FATF recommendations 36 to 40 relating to international cooperation, which deals directly with ensuring that jurisdictions have the legislative and appropriate mechanisms and measures in place to provide reliable, efficient, constructive, and timely cooperation. The FATF methodology on immediate outcome number 2 assesses how effective a jurisdiction requests and provides mutual legal assistance and other forms of international cooperation within its risk and context. To achieve a substantial level of effectiveness, it requires the team efforts of all industry partners. Who are the industry partners? The industry partners are all reporting entities, financial institutions, company managers, and the like, and all competent authorities, LEAs, the AG's chambers, and the governor's office. Each industry partner is required to fulfill its role in the provision of international cooperation. The primary focus, however, is being placed on the role of reporting entities, who I believe to be the critical piece of the puzzle, as they are the main holders of information and intelligence. To fulfill their role as industry partners, they are required to maintain a robust AML CFT compliance program that includes maintaining up-to-date and proper records, that is, records that are complete and stored appropriately for easy retrieval. Ensuring adequate internal controls, which takes into consideration independent audits, and ensuring that ongoing risk-based assessments of both clients and products are taking place. Ensuring training of MLROs and general staff members. MLROs should be kept up to date on trending issues in money laundering, terrorist financing, and proliferation financing, and how it affects their business, which is then trickled down into the general staff body's training program. Most importantly, a program that detects suspicious activities promptly, which leads to timely reporting to the FIU. Reports generate intelligence that can be shared, and therefore it is critical that reporting entities share information in a timely manner with the FIU. It should also provide suitable responses to requests for information from the FIU in a timely manner, providing full responses to the information requested, even if it is thought that it may not be relevant. It also includes understanding the legal requirements under the AML CFT regime. It is important to know that what information is to be kept and for how long, and that there is leeway granted to the FIU to request and receive information that falls outside of the legal retention period. Fulfilling their requirement for a robust compliance program is the epitome of their role as industry partners and the jurisdiction's ability to provide timely and constructive cooperation. Anguilla continues its efforts in facilitating international cooperation with its foreign counterparts. The next two slides show the extent of such international cooperation. The first table depicts incoming and outgoing mutual legal assistance or letters of request. In 2019, there were 6 outgoing requests for evidence related to ongoing investigations, 2 related to MLA USA, and 4 to other jurisdictions under SIGICA. In that year, the jurisdiction received 2 requests for evidence from foreign jurisdictions under SIGICA. In 2020, there were no outgoing requests for evidence. However, the jurisdiction received 3 requests for evidence from foreign jurisdictions also under SIGICA. In 2021, thus far, there was 1 outgoing request for evidence related to an ongoing investigation and 6 incoming requests from foreign jurisdictions under SIGICA. In addition to our cooperation through mutual legal assistance and SIGICA, the FIU also cooperates through secure means in response to requests for intelligence, as well as information disseminated spontaneously. To put this in context, over the past 3 years, the FIU has received a total of 115 SARs as suspicious activity reports. That is 59 in 2019, 35 in 2020, and 21 thus far in 2021. Our cooperation in this regard is depicted in the table being displayed. Spontaneous disseminations for the year 2019 to 2021 were 42 in 2019, 26 in 2020, and 18 in 2021, respectively. In terms of requests for intelligence, the FIU received 18 in 2019, 12 in 2020, and 13 in 2021. The FIU made 21 requests in 2019, 7 in 2020, and 9 requests thus far in 2021 to foreign jurisdictions. The FIU is facilitating its mandate, has made efforts to ensure effectiveness in providing constructive and timely responses to international cooperation, which requires full cooperation from reporting entities. Although this may be the case, in most instances, there are still challenges which hinders this process. In our experience, some of the challenges encountered are timeliness of responses to requests made by the FIU. Anguilla is unique in that it has both domestic and overseas agents, which sometimes poses a delay in the timeliness of responses to written notices for intelligence or search warrants related to MLA matters. As such, these delays affect our timely cooperation with foreign FIUs or international LEAs. Secondly, direct access to all LEA databases is not available to the FIU, which causes a delay in the retrieval of information. This is just facilitated by having to wait for LEAs to provide information. That in itself causes a delay. When requests are accessing information from other jurisdictions, some conditions are unduly restrictive. Requirements of an MOU. Like I said previously, that some jurisdictions might not be on Egmont, and therefore they might require a MOU in order for exchange of information. So in those cases, in order to exchange information, get information from those jurisdictions, a bilateral agreement for the sharing of information would have to be put in place first. In some instances, the nature of and the process in which evidence is being obtained on behalf of the magistrate court is an extensive process which requires a significant amount of time and resources from the FIU. So sometimes the time constraints and the resources poses a difficulty for the FIU. So how can we overcome these challenges? We believe to overcome these challenges, there needs to be a creation of a channel of open dialogue with industry partners in hopes that issues that may arise or concerns that industry partners may have can be addressed immediately to prevent lengthy delays. 2, providing increased training or seminars for competent authorities and industry partners. It is in these seminars that persons get to ask questions and they are become more informed from presentations and so forth, so that they understand what is required of them and how they, in doing their responsibilities, can help us to have more timely international cooperation. Increase the signing of MOUs with foreign jurisdictions for the sharing of information. Sometimes this is a little difficult. It takes time to put in place MOUs. So the time constraints there also pose challenges and how we can overcome the challenges that we do have with providing or exchanging information. 4, establishing joint working groups among competent authorities. And this will speak to the issue of delayed information. Sometimes it is misconstrued as to what the timeliness that is required for providing cooperation. So therefore, having joint working groups where the competent authorities can sit around the table and they can have better understanding as to what is going on and how they can help to speed things along would also help to overcome our challenges. Finally, to ensure we have timely and constructive responses to incoming requests, there needs to be a heightened level of assistance and cooperation between reporting entities and the FIU within the context of legislation. So from the presentation, there are some key takeaways. International cooperation is vital to the jurisdiction's AML-CFT regime. International cooperation must be timely. It is of utter importance for us to make sure that when we are cooperating, we are cooperating in a timely manner. International cooperation is critical in ensuring the technical and effectiveness compliance for the jurisdiction. Reporting entities have a pivotal role in the industry's effectiveness through the maintenance of a robust compliance program and providing timely, adequate, and accurate information so that intelligence can be passed on and enable timely international cooperation. Our challenges can be overcome with increased coordination and dialogue between agencies. We're talking on the competent authority level as well as the reporting entity level. Finally, without international cooperation, we cannot effectively combat money laundering, terrorist financing, and proliferation financing. Thank you. You may contact the FIU at any of our contact details provided, or stay abreast through our website or our Facebook page. The information is provided here. Feel free to look us up and stay tuned for whatever's to come from the FIU. Thank you.